The question is that this bill be now read a second time. I call the member for Coogee.
Thank you, Mr Speaker. I rise today to speak on the Crimes Amendment Zoe's Law Bill 2013, number 2. Mr Speaker, when considering this amendment to the Crimes Act, I read the compelling article by Bronnie Donegan, the mother of Zoe, that she wrote for the online news site Mamma Mia. It was truly heartbreaking read. Losing an unborn child who so desperately is wanted and loved is one of the most devastating things that could ever happen to a person. I'm truly sorry for her and Nick's loss. In trying to understand the gravity of the situation that confronted them, I'm brought back to my own past. My mother suffered similarly a devastating loss. Whilst not the same, her son, my brother, was just 6 years of age when he ran into the street and was struck by a car and died from his injuries. Words cannot express the pain that my mother felt and still feels about losing her youngest child, even almost 40 years on. His death levelled my family for many years and was the cause of so much angst for many, many more years to come for my mum. As a Member of Parliament, however, I have to set aside emotions and personal experiences to truly consider the implications of legislation, and I have seen firsthand the impact and see the potential impact of unintended consequences. On this specific amendment, I came to consider not only that the emotional devastation caused by losing an unborn child, but also the consequences on women's reproductive rights. I've received advice and counsel from legal experts on this difficult matter, including the New South Wales Bar Association and the Australian Medical Association. Both have indicated that this is not a law that should be supported. Both these legal and medical bodies have stressed the negative implications of expanding the legal framework to recognise unborn fetuses as living separate persons. The law as it stands in New South Wales states that a fetus becomes a separate body person when a child is able to take its first breath of air. By legislating that an unborn child has the same status of a fully birthed child would simply add confusion to the legal structure and would have unintended consequences, most importantly by potentially attacking the reproductive rights of women. The amendment would give the courts legal scope to interpret and potentially criminalise the termination of a fetus after 20 weeks of gestation. Any woman seeking termination outside the 20-week period would then be subjected to a lengthy court challenge on the basis that a woman cannot consent to destruction of a person. It could criminalise a woman's right to terminate a pregnancy after 20 weeks. In her online article, Mrs Donegan wrote, "I couldn't reconcile that the child I'd applied for a stillbirth certificate for, held a funeral for, received the baby bonus for, received paid parental leave work for, wasn't recognised separately to me." Mrs Donegan's experience is nothing short of devastating. The bill before the House may seem like an honourable action to take the light of Mrs Donegan's horrific incident, but as an elected member of this chamber, it is my duty to assess the legislative effects of this bill on all female constituents in my electorate. To pass the Crimes Amendment Bill would potentially disempower and endanger women's reproductive rights. The legal confusion that could arise from this bill would be overwhelmingly negative. I think the member for Goulburn, the Honourable Prue Goward, put it perfectly. She said, "One day, someday in the future, our criminal justice system will," and I quote, "seek consistency of definition." Unintended or not, this bill will, if passed into law, one day criminalise abortion. I know that ultimately only one legal opinion matters, that of a judge interpreting this law in the future. Those who drafted this law may no longer be alive when that unintended consequence finally arrives. Based on my and others' scrutiny of the proposed amendments, I cannot support this bill.